that made me write this book. I think there's a lot of books that can be written about outrages on death row and the criminal justice system. And it's interesting, my editor, I had an absolutely brilliant editor at Knopf, as I say when things aren't being recorded. He's brilliant, but he's irascible, curmudgeonly, cranky. This is why he and I get along so well, obviously. And he really pushed me to write a broader book than just about the case, and pushed me to write about the law and the development of the law. I mean, he'd write in the margin things like, what's the role of the prosecutor? What's the role of the defense counsel? What's the role of the jury? I think those things are obvious. And then I'd start doing some reporting and research, and I think, geez, I either was playing golf when those courses were talking about, or I've forgotten everything. But he tells the book from one angle, I tell from another. I'm going to start with the lawyer that handled it on appeal, a woman named Diana Holt. She is truly sui generis. There is no one like her. When Diana was 27 years old, she was on her second husband, one who had tried to kill her, 2 children, no high school diploma. And she was so badly sexually abused growing up by her stepfather that you can barely write it and read about it. And in one place where I spoke earlier, afterwards a friend, and I used to describe some of the things that happened, he came up and said, don't mention that, because you lost the audience for the rest of the evening. That's all they could think about. So I'll leave you to read that. When she was 17, she had something else in her past about which she told no one, not even her adult boys, until about 9 months before this book came out. She cooperated with the book totally. She knew it. She trusted me with her life story. When she was 17 years old, she ran away from home in Houston. She'd had enough of the abuse with some guys she'd met in a bar the night before. They ran out of money after a few days of partying. They hatched this plot. Diana goes, sits on a stool in the French Quarter. Guy comes over. They flirt. They agree on the price. They go out to his car. Her friends run up. Now you really gasp. He reaches under his seat. He's a U.S. Marshal. Nobody's hurt. No damage. She runs. 3 blocks later, she's caught. Goes to prison for 3 years. She gets out of prison. That's when she starts having these domestic quote-unquote problems. I mean, going through husbands, a little unstable. When her husband tried to kill her, the DA in San Marcos refused to prosecute. He said it's his word against yours. We're not going to prosecute. She was furious. She goes to community college, straight A's, and I jokingly say even in golf, community college, straight A's, Southwest Texas State, which is where LBJ went now, in San Marcos, straight A's, gets into the University of Texas Law School. And I give a lot of credit to the University of Texas Law School for admitting her with this background. She gets out and she goes to South Carolina and begins working on this case. That was 1993. At that time, Elmore had been on death row for 11 years. Now we'll back up to the case and what happened to Elmore. In 1982, in Greenwood, South Carolina, the body of a wealthy white woman, Dorothy Eli Edwards. It gets a little complicated because the suspect, the man on death row, is Edward Lee Elmore, and her name is Dorothy Eli Edwards. Her 76-year-old was found stuffed in her closet, stabbed, broken ribs, 1 ear almost ripped off, sexually assaulted, bloodied, battered. 36 hours later, they arrest Elmore. Semi-literate, 23-year-old black man, had worked around the house previously. One of the things that attracted me to this case, it has everything that's in the debate about the death penalty. Mental retardation, racism, black perpetrator or suspect, white victim, snitch testimony, DNA testing, bad lawyers, bad defense counsel. I mean, bad is an understatement. One of his defense counsel was known around town as the Bourbon Cowboy. The other one referred to Elmore as the red-headed nigger. When I interviewed the Bourbon Cowboy many years later, he said, I thought the son of a bitch was guilty then, and I think the son of a bitch is guilty now. They put on no defense. None. The trial lasted, well, he's tried, convicted, and sentenced to death 90 days after the woman's body was. Now, I mean, Texas can't even beat that record. You know, if I jaywalk in Los Angeles, it's going to take them 90 days to get me to trial. The trial lasted 8 days, 2 days picking the jury. The defense put on nothing. 2.5 hours for the jury to find him guilty, 2.5 hours to sentence him to death. It was overturned on appeal. There was a retrial, but the retrial was just to push the replay button. It was an absolute identical 8 days, same witnesses, called in the same order, etc., etc. That was overturned on the sentence. The reason I go through this is because the mantra becomes 3 trials, 3 juries, 36 people, heard the evidence, found him guilty. How can you say he's not guilty? I tell you, Edward Lee Elmore is not guilty. And it's that drew me to the case, and the other thing is the prosecutorial misconduct. I mean, I'm talking prosecutorial misconduct writ large. There's been a lot lately about Brady violations. Those of you law students, Adelaide, of course, knows Brady v. Maryland. I have to tell you, Henry's introduced a lot of people here. I want to introduce Adelaide, who, when she was a little girl, about this high, I've known her, and she swears that or her husband does, swears at me because she comes home from law school and has been working too hard and says that I'm the reason she went to law school. Brady v. Maryland, the Supreme Court said the prosecution has an absolute obligation to turn over all evidence to the defense. In this case, Brady violations are benign. I mean, when the New York Times ran an editorial on the Morton case back in December, Michael Morton case, you know, the Texas case where he was exonerated after it turned out that the prosecution had withheld evidence which showed that he was innocent, I sent a note to the editor, actually Abe Rosenthal's son, whose politics are the opposite of Abe's. I mean, his editorial page is so liberal, and so he's absolutely against the death penalty. He has said so straight out. I said to Andy, Brady violations, read the Elmore case. You know, they didn't withhold evidence, they planted evidence. The police planted evidence at Elmore. I have no problem saying that unequivocally, and they lied. And they lied. Hey, the Fourth Circuit issued an opinion in this case last November, which surprised everybody. That we didn't think it was coming. I think I might have delayed the book had I thought this was going to happen. In which the Fourth Circuit, this isn't the Ninth Circuit, this is the Fourth Circuit. With all due respect, and it is respect, you know. I love the Ninth Circuit. And one of your colleagues is also in the book, Steve Trott, for having the highest ethical standards as a district attorney when he was in Los Angeles, which is the role that prosecutors ought to play, and there aren't many Steve Trotts today. But the Fourth Circuit used the words deceit and outright dishonest when talking about the police handling of this case. The Fourth Circuit, deceit and outright dishonest. And, you know, that's what convicted him. So it's far, far, far worse than just withholding evidence. And I think you should throw your hands up any time to ask any questions. I mean, I can keep rambling as long as you want, ranting and raving. I mean, I feel pretty strongly about it. And if there's no investigation in this case, if there's no federal investigation in this case, you've got a clear 1983 violation. Forget about what I wrote in this book. When the Fourth Circuit uses the words deceit and dishonest, outright dishonest, to talk about the police handling of the case, that's a basis for a federal investigation. If Eric Holder's Justice Department doesn't investigate in this case, I don't think you're ever going to have an investigation, serious investigation. I don't know what the sanctions were in your case, Gloria. Was it the state bar sanctions? Or
yes.
Yeah. Oh.
Yeah.
Keep somebody in jail for 17 years. In this case, they keep a guy in jail for 30 years. 11,000 days he spent in jail, and maybe the state bar sanctions him? Margot.
Committed the murder.
The probable murder, even the Fourth Circuit said that the probable perpetrator is the next door neighbor, Jimmy Holloway Sr. And Jimmy Holloway Sr. was the next door neighbor. He and Mrs. Edwards had been having an affair for a long time, and as I like to say in some audiences, yes, even we old people have fun. And she was going off to get married that way, or to see her boyfriend, and he knew it. They'd lived next door to each other for 35 years. And he went over there on a Monday morning. He says, he testified that he saw the car in the driveway, was surprised she hadn't left, walks over, sees the back door ajar, goes in the kitchen, finds a denture, partial denture, needle nose pliers on the floor. Here's the television blaring, goes to the bedroom, the alarm clock is blaring, sees blood all over the place, sees blood by the closet door ajar. He goes outside, goes back, goes next door, gets Mildred Clark, comes back, goes through the house again, takes out a pair of gloves, which he conveniently has in his back pocket, and opens the door. You know, he should have been the first person the police questioned, but they never questioned him. And one neighbor said to me, I don't know what I was going to tell him because I knew he and Dorothy were having an affair.
Is he still alive?
No, unfortunately, well, fortunately or unfortunately, he's dead. But his son, I mean, the journalism side of this, we always wonder why people talk to us. I mean, I interviewed his son several times. He came to St. Andrews and played golf with me. And the last time he was there, he said, you think my father did it, don't you? And I said, doesn't make any difference what I think, but there's certainly a lot of people who do. I mean, there's other evidence that points to him as the probable perpetrator. And the Fourth Circuit even said he was a probable perpetrator.